People v. Marquese Scott.
May it please the court, Nicholas DeFonso for Marquese Scott. I'd like to reserve 1 minute for rebuttal.
Yes.
Reservation exception applies to this plea challenge because Mr. Scott never had a reasonable opportunity to discover or object to a fundamental defect in his plea.
Why didn't he?
Why didn't he?
Yeah.
Because the court's statements were made at the plea and at the sentence, and they were never challenged or otherwise called into doubt. And there's
Right, isn't that the point, that he could have challenged it? Didn't we say in Williams, you have the opportunity? And wasn't there an opportunity at that stage, or the 5 months in between the plea
No,
and sentencing?
What I mean is the court misadvised Mr. Scott as to the potential sentencing range. And there's nothing in the record that indicates that Mr. Scott knew or should have known that the court had inflated the range by 25 years. So that's what I mean. So an opportunity isn't just an ability to speak. It's something in the record that calls the defect to, or calls attention to the error.
So where is Williams' responsibility?
What was that?
What was his attorney's responsibility with respect to being knowledgeable about his exposure and or taking action when the court, in fact, misstated it?
There's certainly a responsibility to provide meaningful representation, and one would think that would involve accurately informing one's client as to their sentence exposure. And we argue that he did not provide that meaningful representation, at least insofar as he's, there was no strategic reason for him to interject and correct the court at that moment. And that his silence implied sort of an endorsement of the court's
But
statement.
regardless of counsel's responsibility, what was the court's responsibility
Yes,
here?
the court has an independent obligation to create a record of the, showing that the plea was voluntary. And the record here does not show that because it doesn't present, sorry, the record here doesn't show that because Mr. Scott was simply never presented with legitimate alternatives about his potential sentence. So it can't, his plea can't be considered a free choice among legitimate alternatives.
So in footnote 2 of Williams, right, the court said that actual knowledge, a defendant's lack of actual knowledge that an error has occurred despite an opportunity to learn of it doesn't excuse preservation. So I'm trying to understand what to make of that. If the defendant's lack of actual knowledge isn't sufficient, what specifically are you asking us to look at here? Is it that the court itself made an error? Presumably, defendant's counsel could have learned of the error had they checked it out, and presumably the prosecution should have too. So what do we make of that footnote?
Well, the Williams, okay, to understand Williams, in Williams, the court called attention to its own error several times, and there was lots of post-plea litigation, pre-sentence litigation, where they focused on whether or not the court could even impose a sentence it agreed to because of Williams' predicate.
So is the rule you're asking for that if the court itself has no apparent cognizance of an error, that's sufficient not to require preservation? What would you have us hold?
I'm just asking for this court to just stick with the rule as it exists right now, which is a reasonable opportunity to discover or object.
But what does that actually mean? I mean, when there's a question where presumably defense counsel could discover the correct answer, then why is there not an opportunity there that lies? That's what I'm struggling with.
Right. There has to be something on the record that calls attention to the error, because in every other preservation exception case, counsel could have discovered the error on their own in their office when they go home for the day or the next day or
But
whenever.
why couldn't counsel discover this error? It was significant it was a significant error.
Right, so that's why, to make sense of this court's prior cases, the opportunity at issue has to be something that occurs on the record, or like there has to be something going on in the proceedings where it either notifies the defendant or defense counsel of the error, right, or the omission, for instance, like.
Well,
post-report.
why isn't the better path to just do a 440-10 based on ineffective assistance of counsel? Counsel didn't do what they needed to do.
Well, I would say, first of all, that this court in People v. Lurie said that the proper method to raise this issue is through direct appeal, not through a 440. And I gather that that has something to do with the fact that it's a different issue than ineffective assistance, whether or not the court succeeded in creating a record of voluntariness. And that if you were to raise that particular claim on a 440, you might be dismissed for, failing to, because you're just looking at the record to resolve that issue. And there's no off-the-record information necessary, so you should have brought it on appeal, and so it could be dismissed.
Well, maybe there is off-the-record information. Maybe at a 440 hearing, there would be evidence that counsel did in fact tell his client that the cap was 20 years.
Right, but that would be
Shouldn't we be allowed to explore that?
that would be a slightly separate issue, right? Either that would be an ineffectiveness claim, which could be a higher hill to climb, or it could be a claim that the plea was coerced, which is still separate from the issue here, which is whether or not the court succeeded in.
But let's say you had a big trial coming up, exposure is high, similar to this, and they work out a plea bargain, and it's 10 years rather than 20, but the judge says 40. And everybody goes home, maybe a witness dies. In between that plea and the sentencing, the lawyer sits down with the client and says, you know what, that's a mistake. You really were only looking at 20 and you got 10. But, the client says, yeah, but, 20 is a lot and proof was good and I'll take the 10. Now, gets sentenced, there's nothing on the record, only the prior statement. We go 5 years later now, maybe the witness has died or the people have not pursued any of their investigative leads. And now you say, no, I was told it was 40. And under your rule, which I understand why, you're looking solely at the record, but under a 440 rule, the attorney could come in and say, yeah, no, I had that conversation and 10 was a good deal.
Well, yeah, I think the first thing I would say is that here there's no independent, there's no indication in the record that Mr. Scott had any independent knowledge that the court was wrong.
Because you're just looking at the record. But maybe
Yes.
they had that conversation where he was counseled, look, it isn't 40, it's 20, but you got 10, what do you want to do? He said, I want the deal.
I suppose that's true, and under your hypothetical, it could impact the preservation issue on if you were to raise that in a 440.
Why
But you would
shouldn't
still
you have to?
Well,
Why shouldn't you have to do that, since that may happen?
yes.
Maybe a judge goes to this thing, and then that, the judge says this, the lawyer goes back, and
Yeah, I mean, if you're looking, that's true if you're just looking at the preservation, but if you're looking at the voluntariness of the plea itself, I mean, for that, that's frozen in time. And
But I thought we agreed if the judge says this later, again, this is a preservation issue, if the judge says this later, then you had an obligation to object. If the judge comes in at sentencing and says, you know what, Mr. Smith, I made a mistake, your exposure was 20, you would agree you'd have to preserve that.
I would agree with that, yes.
So why, if the lawyer told you that, wouldn't you have an obligation to preserve it?
I mean, I think that this court has functionally held that very thing in People v. Peke, right? So Mr. Peke had independent knowledge, so he was required to preserve, whereas Mr. Diaz is more similar to Mr. Scott here. Nothing in the record that he knew, so preservation exception applied to his case, and that's what we're arguing here.
But doesn't that get you back to the footnote in Williams? It's not actual knowledge of the error, it's simply an opportunity to discover the error.
Yes, but that has to mean that there's something in the record that created that opportunity.
And we don't know what the record is. I think that's the point that some of my colleagues was making. If this was a 440, it would be fleshed out, all those interstices between when they were on the record. Defendant might have learned something, such as, don't listen to the judge. It's really capped at 20 years here.
Well, no, I mean the record on appeal, because if a 440 record were what was required for an opportunity to discover, then that would have to be true for every other preservation exception case, and it hasn't been required there.
Can I just clarify, let's stay with the hypothetical you're working with, that the lawyer actually does, at some point before sentencing, say, that was incorrect information. It's not 15 plus 15 plus 15. There's a cap. It's only 20, right? All of that. When the judge then at sentencing repeats that the exposure is 45, give that incorrect information, and ask the defendant, you're aware of that, yes, sir? And the defendant
Yes.
says, oh, yes. Is defense counsel, is there any duty or obligation for them to put anything on the record? I think I know what your answer is, but I wanted to confirm with you.
Does defense counsel have an obligation to correct the court?
Correct.
If counsel knows what the court is saying is wrong, I think is the hypothetical.
Yes, 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 because counsel has told defendant before the sentencing, that was wrong, it's really 20, not 45.
I think to be effective, yes, if he wants to safeguard his client's decision-making ability, he needs to interject and correct the court so that the client doesn't rely on the court's misstatement here in making a decision on what to do. So yeah, I think that he does or
If counsel figures it out before sentencing.
yes, yeah, that's what I would think.
Thank you.
Did he say it here? Did the judge say the exposure again at sentencing?
He did, and he said it in the context of, that he could enhance the sentence up to 45 years, and does the client still want to invite the probation officer over to testify? And again, the statements were never corrected or called into question in any way, like in Williams, right, where there was always sort of constant pervading doubt about the promised sentence and the legality of it, enough doubt to, really blame the defense for not resolving that ahead of time before then complaining about whether or not the plea was voluntary based on that. There's nothing like that happened in this case, and there's no indication of independent knowledge. And again, just to emphasize that we're not asking for the preservation exception to be expanded here, just for it to be applied as it's currently written.
Thank you.
May it please the court, Michael Hillary for the people. Preservation is the rule, and the exception is to be applied in the rare case, as this court has said.
But how do we know on this record that he was aware that this was incorrect?
We don't know, Judge, that he was, which I think
And
underscores.
doesn't the court have an overall responsibility to make sure that a defendant standing before him to take a plea must do so in a knowing and intelligent manner, and that the court itself must provide accurate information?
Yeah, yes, Judge, that's correct. That's correct.
So how does that impact when the judge not only once, but repeats it and grossly does so? How is this different from deportation cases where inaccurate information is given?
Well, Your Honor, this court has said that misinformation when it comes to maximum sentence exposure, with this most definitely was, there's no way around it, and it was significant, is but a factor and not a determinant
Correct,
factor.
a factor, but you have to also look at the other things that are going on here. So the gross miscalculation is a factor. It's a significant factor.
To be sure.
What about when the defendant goes to probation and says, I took that plea because I was facing a lot of time? Doesn't that also go to, I relied upon that information in making that decision? Shouldn't we be concerned about that?
Certainly relevant, Your Honor, although there is a little bit of ambiguity, because even had he been told the correct maximum sentence exposure, 20 years, He was getting 6 to 8 and possibly 3.5. So that statement that he made to the probation officer would be just as applicable in that scenario
But he
as
was
it would had
23.
I'm sorry.
He was 23.
Yes.
Get out in his 40s, I'll give you the max on that, versus getting out in his 60s. Your whole life is left for you if you're getting out at 40.
Absolutely, Judge, it's significant, and there's no way around that fact.
And
But I,
before he made the decision to plead guilty, he was given this information by the court, this inaccurate information, grossly inaccurate information. So I agree with you, it's not just one thing, you have to look at everything in the circumstances. But should we not be concerned that this number is so grossly wrong that it's coercive?
it's a fair concern, Judge, and to be perfectly candid, I mean, looking at it as an advocate myself, I was concerned and am concerned.
It's almost half a century.
But in considering this, Your Honors, there are multiple, as Your Honor has indicated, there are multiple factors in play here.
So what are the factors that cut in the other direction? It does look to me that at some point during the allocution, there's a statement from defense counsel that indicates that he was concerned about the length of the sentence. He says he wants to make sure he's not just hearing minimum 3.5, and then in 10 weeks when he appears for sentencing, he's going to say, I thought you were going to give me 3.5, which suggests that there is some focus on the length of sentence. What cuts in the other direction in your view?
Well, Judge, that certainly is a big one right there.
Okay, so what exactly is on the other side?
You're saying, Judge, if I understand your question.
Well, I think we all agree, but correct me if I'm wrong. You said, and I believe someone else said, that you look at, this is one of multiple factors that you consider, right? And so I think that we know that the statement about the exposure was substantially wrong by decades. And there is, at least in my view, perhaps some indication in the record that the defendant was concerned about the length of sentence that he might receive. So what other specific facts in the record would you point us to which might lead us to conclude that it was in fact voluntary?
Well, Judge, there are several factors that this court has articulated as to how to properly evaluate comprehensively a plea. That includes the severity of the charges. These were second-degree burglary charges. That includes the age and experience of the defendant, and that includes the terms of the bargain and the reasonableness of the bargain. So if we look at, for example, the age and experience of the defendant, he wasn't a juvenile, he was in his 20s, but that even tends to obscure his experience with the criminal justice system. He was about 22, if memory serves. 2011, person in need of supervision.
But doesn't that go to the question of whether or not he would reasonably apprehend the parameters of the bargain that he was getting, which was off by quite a substantial number of years, given what he was told by the judge?
It does go to that, Judge, but it also goes to his ability to discern what is, in fact, a good deal.
But Mr. Hillary, his record, juvenile offender misdemeanors are quite different from being a prior or a persistent felon and knowledgeable in the criminal justice system with respect to the realistic exposure of double-digit sentencing. That's different. And the consequences of even staying in a state institution versus a local or juvenile facility.
I absolutely agree with that, Your Honor. I'm only indicating that given his experience with the criminal justice system and presumably his experience with working with attorneys, being counseled.
That's not, it's the experience that you're referring to. You would agree a juvenile, and even his maturity at the time of using the term juvenile, that cuts against your argument that he's knowledgeable and experienced because of one's capacity to understand and appreciate. What I'm more concerned, let's go back to the court's core responsibility as an officer that is imposing justice. The court has the paramount responsibility. I certainly question the attorney's role here, but the court itself, and the court repeatedly exaggerated the amount of time. That smells of coercion. And and the court's failure to fulfill its own responsibility. And that is concerning to me.
I appreciate that, Judge, and I don't disagree that it's concerning. I really don't. This court, again, has indicated that there are multiple factors. The exposure, sentencing exposure is but one. It's not determinative. It may be significant, but it's not determinative. If we were to say that that factor was determinative, I think we would be on equal footing at least to say that just as determinative is the nature of the deal that the defendant gets. When we get beneath that issue, and certainly there's a misstatement to be reckoned with, but when we get beneath that issue, what we're left with is a defendant who was convicted of 3 second-degree burglary counts, and he got 6 to 8, or at least he was in line to get 6 to 8.
It does seem that that is your strongest argument, that even if he was correctly informed that it was 20, it's less than half the time.
Exactly, Judge, and I don't want to speculate, but perhaps one of the reasons why counsel didn't dig in to determine whether or not this was a gross misstatement is simply because looking at the nature of the bargain and defendant's willingness and desire to take
But
such a good bargain.
Couldn't also the attorney take into consideration whom the attorney was appearing in front of, and that the sentence could get, the commitment could change and not necessarily in the favor of the defendant? Isn't that also a possibility?
It's quite possible, and in fact, the advocate for this defendant did in fact make sure that he was aware of it in court, that he might not get the 3.5 that was on the table if he assisted the prosecution in an unrelated case.
Taking into consideration whom the defendant was appearing in front of.
It's true. That's true, Your Honor.
Thank you.
Sorry, I'm not sure if my,
No, you still have time. I'm wondering if we were to affirm, what really is left of Lurie?
I think the distinction, Judge, if I can attempt to draw one between Laurie and this case, is that Laurie dealt with the failure to mention altogether a sentence component. So in this case, for example, we have
We could say all the same things, right? And Lurie says this is not appropriate for a 440 because you can see this on the face of the record, right?
Right.
But you could say all the same things there. That is, counsel may have known that PRS was required and decided not to say it because this was actually a good deal and PRS really didn't matter to the defendant. So we discounted, or at least, it wouldn't be consistent with our holding Lurie to rely on rationales like that. And here, in Lurie, the court forgot to say something it was supposed to say. And here the court affirmatively said something that is terribly wrong. That seems worse.
Yes, it does seem worse.
And the terribly wrong thing was years of incarceration, not years of supervision outside of prison.
But he does have recourse. The defendant did have, as the court has indicated, he does have recourse. That recourse is an ineffective claim under CPL 44010.
Why isn't that true for the other cases?
I'm sorry, Judge?
Why wasn't that true in the other cases? Where we've recognized the exception.
Well, so CPL 44010 now allows a defendant, and an ineffective claim, allows a defendant to bring a challenge concerning a claim that otherwise was required to be a matter of record. Not so anymore. He can bring an ineffective claim even though it's not a matter of, I'm sorry, it is a matter of record. He can bring an ineffective claim now despite the fact that it is a matter of record.
So you're
That wasn't
saying
always
the
the case.
Lurie rule is unnecessary at this point? Is that your argument?
No, it's not that it's unnecessary, Judge. It's just that, and specifically here, in the case of an ineffective claim, this defendant can challenge the effectiveness of counsel based upon that misinformation, where he otherwise could not have in the past.
But as I understand, the only purpose of that is to confirm whether or not he's gaming the system and he actually did know. Whereas what we face here is everybody got it wrong. Why would he know? Judge doesn't get it right, the prosecutor doesn't get it right, defense counsel makes no correction. Why should a defendant? Why should the defendant know?
Well, I'm not saying that the defendant himself necessarily should have known. I see my time is up, if I could just complete the, I'm not saying the defendant himself should have known, but he has an attorney who should have known, and
And he has a judge in front of him who should have known.
True, true, but he has
And who is
recourse.
responsible to ensure that the gentleman knows that what the court is saying is accurate information and that the individual is making a decision based on that accurate information. That's voluntary, intelligent, and knowing, right?
There's no question, Your Honor, that what happened in this plea proceeding was off-key with the nature and objective of a valid plea proceeding. But it is also true that that factor alone is not dispositive, and it is also true that the defendant has the wherewithal to bring an ineffective claim of counsel claim, and he can challenge the effectiveness of counsel for failure. And the court incidentally...
So then you disagree, I'm sorry, with counsel that if indeed the lawyer knew before sentencing, let's say after the colloquy, before sentencing knew that the judge had made a misstatement, does the attorney have to correct that? Or at least if the, as in this case, the judge repeats that at sentencing?
I
Do you agree?
believe, personally, Judge, I believe the attorney has an obligation to correct the court, even if he's on the side said to the defendant, you know, don't worry what the court says, this is the fact. I think as an officer of the court, if you know that information is incorrect, you have an obligation to speak up, whether you're the prosecutor or the defense.
Let's say for one moment he didn't. But nevertheless, the judge says to the defendant, you understand that the exposure is 45. You think then, and the defendant says yes.
Yeah.
Lawyer would know that that is an incorrect statement, to say the least, to the court, no?
Yes, Your Honor. Yes, I think there's clearly an obligation there.
Counsel, you know, I asked the 440 hypothetical before, and there is an appeal to that in the scenario I gave, but part of this is aimed at not having to do a 440, right, and having correct information imparted. And if we just say, okay, you know, you can recreate this in a 440, don't worry about it, does that send the wrong message to a judge in a plea proceeding to say, you know, I'll figure it out later, or you can figure it out later, or your lawyer must have told you. And if that doesn't happen, we're going to all be back here doing a 440, or the message being the court has this obligation to get it right.
Well, certainly, Judge, if it's a preserved argument, I mean, the judge who presided over that misinformation is going to presumably he's going to get a decision based on his case that points out the flaw. He's going to be aware of it. So I don't see an ineffective claim as bypassing judicial accountability and responsibility in
But
this
what
case.
about judicial accountability in the first instance? What kind of a message does it send if judges aren't reminded of the importance of being careful? I'm not talking about a minor mistake. I'm talking about grossly misstating and then doubling down on. What kind of message, I believe, what does that send?
Does just having a
With the
440 motion, Judge?
No, with just saying with it, well, you can check it out later in the 440. What does that send to the court? I don't have to be careful. Isn't that doing the opposite of what should be done?
Well, the court might think differently if he succeeds on a 440 and the case is back before that judge. And I'm not saying that at all to be flip. I think a judge, I would assume a judge who gets a case back that he or she presided over, whose error is responsible for that case coming back before him, and now all the exhausting of judicial resources goes on again, I would think that's a severe...
We would hope.
I would hope. I would hope that disincentivizes judges to be lax with regard
That
to...
depends on the actual 440,
It would, the success of the 440,
or it even gets filed.
yes.
Thank you.
Thank you.
Just briefly, Your Honors, I would note that Mr. Scott never accepted the offer to cooperate and get 3.5 years, and that's in the record. So it was really just a decision about whether to take a 6 to 8, or in his mind, risk receiving a 45-year sentence. And I just wanted to note that when you stack an extra 25 years onto a potential maximum, that just raises the stakes and you need a correspondingly severe level of risk tolerance to accept that and go to trial. Otherwise, no one is going to accept that. The correct decision for them will be to take the plea. So it does smack of coercion, self-evidently. And I think that in the totality, there's no call to change the totality of the circumstances test here, but where the inaccurate sentence information is so severe, like it is in this case.
Is that your limiting principle, that it has to be so severe? If he had misstated it by 3 years, or if he had said the wrong amount for a fine, or the restitution was wrong, would that excuse preservation in your mind? Like, how are you defining?
Well, I'm not
the
talking about
limiting
preservation
principle?
right now. I'm talking about whether or not the plea was voluntary. And so,
Okay, so in that circumstance, too, let's go to the merits and then go to preservation. So
Sure.
in that case, if it was a 3-year, which is significant
it'd be a
in
closer.
anyone's life,
I mean, you have to look at the context of the case and the totality of the circumstances, right? And the terms and absolute terms as well. But it'd be a closer call. And I think I say this in my brief, when you have, differences that are not so stark.
so would the preservation exception then apply?
Preservation exception would still apply so long as there was, under the facts here, yes. But if it was too close to call, so if you decided that it wasn't involuntary as a matter of law, right, you would then
Well,
send it
we'd
back.
start with preservation first, right? So is this preserved, or is there an exception to the preservation rule? And you're saying here, there's an exception because the judge misstated his potential sentence, correct? And I'm just saying, how far are you extending that preservation exception?
Well, I'm saying that the preservation exception applies because there's yes, I mean, what you're saying, there's an error that's plain on the face of the record, and it's fundamental, and it was never corrected. It was repeated at sentencing, and so there's never what's been referred to in the case law as like a reasonable opportunity to discover that error and object to it. So that's why the preservation exception applies.
Right, so I guess I'm trying to figure out what you consider fundamental. I mean, I think we see here every day, judges make mistakes about whether to sit jurors or for cause, or whether to allow in evidence, and we require preservation.
Yes,
So is it the nature of the sentence? Is it the nature of the error that allows for this exception to
I think
preservation?
it's an error that could potentially render the plea involuntary, and I think that because of People versus Peke, and how the rule there is that, well, this court recognized that the failure to inform the defendant of the deportation consequences could have rendered the plea involuntary if the defendant would not have pled guilty had he known about
Right,
those
but do you
consequences.
think Peke is different just because a defense attorney, it might not be in their wheelhouse about deportation and immigration law, that they'd have to go back and research it, where something like mandatory exposure to a sentence is something that we presume is within the job of a defense attorney?
I mean, I don't see how, I don't see the connection here. I thought we were talking about what kind of error counts as a fundamental error. And under Peke, since the preservation exception, for instance, in Diaz, applied, and you didn't know whether or not that error rendered his plea involuntary, that means that the truth of the error as to that specific plea is irrelevant as to whether or not the preservation exception applies. It's sort of like a category of error that counts as fundamental error.
Thank you.